Charter of Gordon, section 2.17, provides that the mayor may be removed or shall be removed from office for any one or more of the following causes. And the first one is incompetence, misfeasance, or malfeasance in office. And those are interesting terms. They're different terms. They mean different things. Incompetence is a lack of ability. Misfeasance is the wrongful and injurious exercise of legal authority. Malfeasance is the performance by a public official of an act that is legally unjustified, harmful, or contrary to the law. The evidence in this case will show over the next 2 days probably that Mayor Liu has been incompetent, has been misfeasant, has been malfeasant. She's been all three. And Your Honor asked a question in one of our first hearings, which was the same question I asked my clients when they first came to my office. And that is, how much incompetence, how much misfeasance, how much malfeasance? Certainly the point of the Code of Gordon, the Charter of Gordon, is not to remove a public elected official for one act. And I agree with that. But what the evidence will show is we're not here about one act. We're not here about 2 acts. We're not here about 3 acts. We're here about dozens of acts of incompetence, misfeasance, and malfeasance. When we filed this suit, and as we've amended it, we've included 28 counts of violating the Open Meetings Act. And we did that to demonstrate primarily multiple violations of that act over time, starting on January 17th, at least on January 17th, and continuing through the month of February 2014. And the evidence is going to show that, yes, Mayor Liu has claimed throughout that she didn't receive the charter in a timely fashion. She didn't receive training on the Open Meetings Act. But the evidence will show that at the latest, on February 3rd, she wrote a memo to Terry Eady in which she said that Joe Boone had instructed her on the Open Meetings Act on January 30th, and that Joe Boone had discussed with her personnel files and the keys to those files on January 30th. And the record will show that she was in fact receiving training. She was in fact receiving instruction. And I believe that the evidence will show that the mayor actually has a background that sat on the school board before, had other public offices that would have instructed her on the Open Meetings Act as well. And the reason that the Open Meetings Act violations become important is because it shows a mindset of Mayor Lou. It shows an arrogance of Mayor Lou. And that arrogance carries through to the other acts that form the basis of our complaint. It carries through to her voting in May of 2014 in a 3-2 vote. And Your Honor will recall the charter says the mayor can vote. There's some situations she can always vote, like involving the employment of certain sorts of city officials. But generally, she can only vote in a 3-3 tie. And we know that the city attorney position is not one in which she can always vote because the Supreme Court has clarified that for us, I believe, in the Jones versus Boone decision. And the arrogance that you see in the violations of the Open Meetings Act, despite receiving instructions in it, is the same arrogance that leads her in a 3-2 vote where Councilwoman Tolles and Councilwoman Whipple and Councilman Reese had voted to terminate Joe Boone's service as a city attorney, and Councilman Dinsley and Councilman Smallwood voted negatively. Councilman Edie had abstained, and that did not create a tie. And we see her, despite orders from this court about when she could vote and how she could vote, despite a lawsuit about when she could vote and how she could vote, and legal argument in this court about when she could vote and how she could vote, she still cast a vote in a 3-2 scenario to terminate Joe Boone's services. Then there was another vote, again 3-2, same lineup of the city council, to delegate all authority to her to hire this other man, Ronnie Jones, to be the city attorney. There was no tie, but yet she voted again. That's the same arrogance we see that arises in the Open Meetings Act violations. The same disdain for the law and the unwillingness to follow it. And the reason that's important isn't just because the city of Gordon keeps getting plunged into superfluous litigation, EEOC complaints, and a lawsuit between Mr. Jones and Mr. Boone, but the reason it's important is because it was clear she couldn't vote. And in fact, the evidence will show that maybe 20 days or a month before that meeting where the city council voted to terminate Mr. Boone's services, and that vote didn't pass, but there was a vote on Mr. Boone's services, there was a vote on delegating authority to the mayor, the evidence will show that long before that, the mayor had reached out to Ronnie Jones and hired him with no approval whatsoever. She doesn't care. It's the same arrogance that manifests itself when she meets with Councilman Reese, Councilwoman Tolles, and Tawana Brown, and discusses, and Councilman Smallwood, and discusses whether or not to pay Bill Baskett, the forensic accountant, who had never been hired by city council. They voted, of course, in February of 2014, February 17th, they voted to hire Mr. Baskett to perform an audit. And then in the subsequent vote to allocate funds to pay him, they never allocated the funds. And they never signed an engagement letter with him because they never could pay him. And the concern of Councilman Edie and Councilman Dinsley and others was Mr. Baskett, and this isn't uncommon in forensic accounting. I'm not criticizing Mr. Baskett for this. But he couldn't tell them how much it would cost because he didn't know when the investigation would end. And Mr. Baskett still gets retained, and the mayor orders Tawana Brown to cut a $10,000 check to Mr. Baskett for his retainer. And then Mr. Baskett is running up bills in this forensic audit of $11,000, $8,000. They keep going up. You'll recall he testified at a prior hearing here. And as he testifies and as he works, his bill keeps getting higher. And then the mayor goes back to Tawana Brown and says, "You got to pay him." And she says, "Well, Mayor, the funds were never allocated. I'm not authorized under the code of Gordon to cut a check." So what does the mayor do? She writes up Tawana Brown for insubordination. And that's the same arrogance, that's the same mindset that you see in the Open Meetings Act violations, this disdain for the law, complete lack of concern for what city council does. And it's also the way she treats Tawana Brown on a regular basis. Tawana Brown's filed multiple EEOC complaints against the city since the mayor took office because of her treatment. The city settled those complaints. And the fact of the matter is, she feels like she works in a hostile work environment. She'll describe that to the court far better than I can. And she's going to be probably our first witness to testify, will be the city clerk. And then also, who I want to note, for purposes of the record, is here because I subpoenaed her. She is not cooperating with the plaintiffs. We talked to her for the first time this weekend once she had received the subpoena and she called with questions. And we also served her with a subpoena of usus tecum to secure city records in case there's some issue as to whether or not we have authentic copies, although there are no authenticity objections raised. In an abundance of caution, we asked her to bring the minute books and everything else. And she'll testify about those things. And we'll also hear from Chief Mike Hall, who will be one of our final witnesses, who will talk about the disruption of the police force and what it's been like to work under Mayor Liu and the fact that his job's been threatened for over a year. In general turbulence that the mayor has brought to office. Another thing we're going to hear about, and this is the same mindset that you see with the money being paid to Mr. Basket. It's the same mindset you see with the Open Meetings Act violations. It's the same mindset you see with her other actions. January 5th, 2015, the City Council has a motion before it. And this motion was made by Councilman Edie, one of my clients, to withdraw $150,000 from the city's Georgia Fund 1, to meet the city's financial obligations. Councilman Dinsley, another plaintiff, seconded that motion. Councilman Smallwood joined them in voting affirmatively for it. Yet council members Tolles and Whipple abstained, and I believe Councilman Reese had passed away by that point. For whatever reason, there were only 5 council people there. Again, that's a 3-2 vote. Now, that's a vote on a motion that our clients, the plaintiffs, made and were in favor of, but it doesn't pass. And the law says it doesn't pass. Yet the mayor, on January 16th of the next meeting, it comes out the mayor, after the meeting with no motion passing, went and withdrew the $150,000 from the Georgia Fund 1 to pay the city's financial obligations. Yes, I'm glad that the city met its obligations. Yes, my clients made that motion. But it's the same disdain for city council. There was no passed motion. There was no approval to withdraw those funds. And the defendant will likely argue that she's talked to somebody in the state and she was told she had the legal ability to do it. I think what she was told, and I think the fact of the matter is, she's a signature on that account, and she is legally able to withdraw funds if there is a motion that passes, and she's authorized to do so. Here she was not. So, there's going to be a variety of witnesses. We're also going to call a man named Roy Mixon to testify, who will talk about one of the incidents down at the depot when she drilled out the locks, despite the fact that he's standing there with the key, saying, here you go, you don't need to drill these locks. But she drills the locks anyway, she pays to have that done. Chief Hall will testify. Councilman Edie's going to testify largely about what the court's heard from him before in order to perfect the record. Councilman Dinsley's going to testify about the disruptions at City Hall and about the treatment of Tawana Brown, something he feels very strongly about. And that's going to be our case. And I think we're going to prove, first of all, I do think we're going to prove all these Open Meetings Act violations I've set forth in the letter. I think we're going to show the financial misfeasance we've alleged. I think we're going to show the personnel issues we've alleged. We're going to show that the mayor has not only taken personnel files out of the clerk's office, and she's, of course, the record custodian who has to certify that everything's there. We're going to show evidence of instances where the mayor has pulled out the minute books, left them unaccompanied in a room, not Ms. Brown's office, and allowed members of the public to just sit there with them, such that Ms. Brown is, I think she'll testify, uncomfortable even telling this court that the minute books are complete, solely because she thinks they are, but what if they're not? They've been exposed to the public with no supervision. And I think in the end, what we will see is that there hasn't been 1 or 2 instances of incompetence, misfeasance, and malfeasance. There's been a lot of incompetence, and there's been a lot of misfeasance, and there's been a lot of malfeasance. And I always go back to the question of how much and how do you know when you've got enough? And I don't have a firm answer to that, but I think it's like obscenity. You know it when you see it, and there's been enough in this case to know that we think under Section 2.17 of the Code and Charter of Gordon, it's time for Mayor Liu to be removed from office. Thank you.
second question he asked him was, is she the first person to ever be removed from office in the city of Gordon? And he said he didn't know the answer to that question. And then when we got the opinion back from the Supreme Court on June 15th of last year, the first line of the opinion was that Mayor Lou is the first black mayor of the city of Gordon. Now, I made no bones about my feelings about this entire litigation from the beginning. And that is that it was racially motivated and racially maintained. And as we stand here today, my opinion is exactly the same. I sat here and listened to Mr. Cooper talk about the definition of incompetence, malfeasance, and misfeasance. I have no clue where he got those definitions from. Don't dispute that they may be accurate. They're certainly not within the law of the state of Georgia. They're not in the city charter of the city of Gordon. I don't know where he got those definitions from. The word that he used the most in his opening statement was the word arrogance. He used that word at least 6 or 7 times in describing the mayor. And essentially that's what this is all about. They don't like her attitude. She's a black female, first black mayor of the city of Gordon, and she's arrogant. And that's what this is about. In their opinion, it's about her arrogance. And I would submit that, whatever the definition of incompetence is not arrogant. Whatever the definition of malfeasance is, it's not arrogant. Whatever the definition of misfeasance is, it's not arrogant. You can't remove a person from office because you think they are arrogant. And that's what this case is about. A black female woman who took the office of mayor in this small town in middle Georgia, who a lot of people sitting out here in this audience don't like because she's arrogant. It's not about Open Meetings Act. We disposed of that with regards to the Supreme Court's decision. We proceeded in this case from March the 9th, 2014, all the way to June the 15th, March the 9th of 13, all the way to June the 15th of 2015, on the theory that 4 people constituted a quorum, including the mayor and 3 council people. And the Supreme Court dispensed with that. Then they came back, and in January of this year, in one paragraph of a 300-paragraph amended complaint, they mentioned the word committee. Throughout their complaint, they don't say anything about a quorum of a committee until January 29th of this year. In one paragraph, paragraph 225, they mention a word that the mayor violated a quorum of a committee. So this case has all been pumped up over some legalities that are alleged that she violated with regards to the Open Meetings Act that never occurred, and it took approximately 16 months of litigation up to the Georgia Supreme Court to get that straight as to what the quorum requirements were with regards to the City of Gordon charter, which said that 4 council people constitute a quorum. She never met with 4 council people. She met with 3 council people because she had always been advised that if she met with 3 council people, then that was not a violation of the Open Meetings Act. We got I believe it's a 32-count complaint, and approximately all but 8 of those counts are dealing with the Open Meetings Act, none of which have been violated by virtue of what the Supreme Court stated. And of course, we claim that, this whole amendment process is unlawful and illegal because it was prevented by res judicata. But that aside, even under their amended complaint, they only allege 1 paragraph where they said the mayor participated with a committee. Paragraph 225. talk about her arrogance, and her creation of general turbulence. Well, I don't know what general turbulence is. They talk about the Georgia Fund 1. Well, the mayor, under the charter, is the administrative head of government for the city of Ward. There was not enough money to pay the employees of the city of Ward. There's a resolution, and apparently Mr. Cooper just apparently forgotten about the fact that there's a resolution signed by the council authorizing the mayor to move money under the General Fund 1 account. Prior to this vote where they wanted the employees not to be paid, they voted that the mayor shouldn't move the money. His clients voted that the mayor should not move the money to pay the city's employees. That was the whole purpose of moving the money, was to pay the employees. So his clients wanted the mayor to look bad, so they voted to make it a situation where the employees of the city would not get paid. The mayor refused to go along with that, and under the authority that she had with the state treasury, she authorized the movement of $150,000 into the city's account so that the city employees could get paid. But yet, she is the one that's malfeasant and misfeasant and incompetent. But even though they are the ones that are voting not to pay the city employees, now tell me who's responsible under that circumstance. And then they come back and use that to remove her from office by saying that she's arrogant. She defied the city council by moving money that she's authorized to move as a signatory on the account, and also by virtue of a resolution. And Judge, if you look at the amendment to the complaint where they made that amendment, and I believe that amendment was made in that first amended complaint. They attached documents to that amendment as exhibits. And one of those exhibits is a resolution that had been passed by the city council authorizing the mayor to have authority to move money from the Georgia Fund 1 account into the city of Gordon payroll account. So Judge, this case at this point in time, 30 months into her tenure as the mayor, which was filed 2 months into her tenure as the mayor, claiming Open Meetings Act violations. And now here we are 30 months into her tenure as mayor. The city of Gordon is still doing what it's always done. It's still there, still functioning. And yeah, they may not like her. They may not like her politics, some of them, particularly these two council people that are on this case, that are parties to this case. But there's nothing here, Judge, that indicates incompetence, malfeasance, or misfeasance, and at this point, it's rather anticlimactic. She served over 60% of her term in office. Nobody's died under her tenure. City employees are still functioning, getting paid. And yes, 3 days into her tenure, these people you're going to hear from that he's calling, to Warren Brown, Mike Hall, and a couple others, filed EEOC complaints against her 3 days after she was in office. And true, the city paid it because they had the votes. They wanted to embarrass the mayor, so yes, they paid them. 3 days after she had been in office, they filed EEOC complaints on her. Multiple times, because that's what they do. So there you have it, Judge. I mean, this case is about race. Pure and simple. And I don't mind calling it out because that's what it's about. And I've been practicing law quite a bit, a long time. And perhaps in my old age, my daughter told me I'm getting old, and I tend tend, the old people tend to say what they feel and say what they think without going to that little box that's supposed to filter what you say. So I'm working on that. But in this case, I've not been able to get that box to work in terms of filtering the fact that this is a racist case. Pure and simple. It's all about race. Judge Benham saw it. That's why he made the first sentence of his opinion that Mayor Lou was the first black mayor for the city of Gordon. Now, what relevance did that have to the issue of the case? Absolutely none, except that that is the issue. That was the first question he asked Mr. Cooper when he was arguing the case. Everybody can see it, Judge. We all see it. It's plain as day. And that's what this is about. Thank you.
Who has called Ms. Tawana Brown, but individually in her capacity as clerk of the city of Gordon, acceptable to defendant, refers to at one time as the caller acceptable.
Tawana Brown. Tell us your name.
I am Tawana Brown.
Well, you can ask any questions that you were attorney asked.
Good morning, Ms. Brown. How are you?
I'm fine today.
Doing well, thank you. Would you please introduce yourself to the court?
I am Tawana Brown.
He reserved his objection, and you never ruled on the motion.
Well, he agreed to have it played.
I just want to make sure that the document that CD contains what I just saw.
Right. I don't have a reason to think it doesn't, but,
I just want, before it goes in the record, I can see a paper document, I can see what it is, but I can't see what's.
that's fine. Yep, I'm with you. I'll let you play it on my laptop if you can. I'll watch the video, see what it is.
That's all the rebuttal on this without your honor.
Sir, rebuttal?
No.
All right. The evidence is now closed. Closing argument. She has the right to open and conclude since you're the plaintiff.
Reserve the right to release.
Yes.
I'm not gonna be too long, Judge. We've seen and heard in the last couple of days. This case started out back in March of 2014, after Mayor Lou had been in office for approximately 60 days, having been sworn in on January 6th. And at the time that the original complaint was filed, it was all about Mayor Lou having violated the Open Meetings Act by virtue of the fact that she supposedly had had a meeting with 3 council people in the city of Gordon, and that therefore she was violating the Open Meetings Act. There had been these allegations that had gone to the Attorney General. The Attorney General had had a meeting with Mr. Ritter. In fact, I was at the city of Gordon participating in that meeting with Mr. Ritter. And those allegations basically went nowhere once everybody realized that it takes 4 people did not have any Open Meetings Act violations. She was a new mayor, learning the role of being a mayor.
She didn't have any open meeting violations, but obviously, she just admitted on the witness stand for one.
Well, at the time, you're talking about the February 4th meeting? Well, you know, Judge,
I mean, I just don't want the record to say there was none, when people read these things, and, she admitted to at least that.
well, yeah. It's hard for me as a lawyer to say that that's an Open Meetings Act violation when the night before she had a meeting, with the council, relying on the advice of a lawyer that she certainly does not trust. And with regards to that memo that she wrote, where, that Mr. Cooper pointed out, when she wrote it to herself, and the number 10 item on that memo is to get a new attorney or to advertise for a new attorney. The only problem I have with that memo is that should have been number 1 item. She should have been able to get rid of Mr. Boone from day one. He is the person that is the reason why we're here today. His confidential memo that he gave to, I don't know if he gave them to Mr. Cooper or gave them to Mr. Eady. You look at exhibits A and D of the complaint, they are his memos to the council providing legal advice, confidential legal advice. And these memos are sent to the media, there's news reports about them, they're in the paper, where he is accusing his own client falsely of having violated.
There's no evidence whatsoever of any of this. There's really no evidence up to this case.
So they were attached to the, I remember the memos, they were attached to the complaint, but they've not been put in evidence here.
They ain't evidence because they attached the complaint.
That's not evidence.
That is evidence. Cobb County versus Stemple. Anything that's attached to a complaint is a plea.
It's not evidence.
You're right, technically, yeah.
Yeah.
But there are documents that are in the file, they've been admitted as exhibits to other motions, et cetera, et cetera. So here we are with an attorney who she's relying upon to give her advice as a new mayor. And instead, he's sending memos accusing not only her, but other members of the city council of having violated the Open Meetings Act, and in my opinion, falsely accusing them of having violated the Open Meetings Act.
Again, I object, there's no accusation in those memos. He could have put Mr. Boone on the stand to defend himself if he wanted to do that.
Mr. Boone now apparently misunderstood or misinterpreted the Open Meetings Act, as I did. I readily admit that, before the Supreme Court ruled, I was fully convinced that 3 and the mayor were enough, because that's all it takes to pass any ordinance is 3 and the mayor. And if 3 and the mayor vote to pass an ordinance, and a 3-3 tie, 3 and the mayor can pass an ordinance, that's enough to do business. I was convinced that that would be a violation of the Open Meetings Act. The court said I was wrong. But Mr. Boone apparently was under the same misapprehension prior to the Supreme Court ruling. So don't say he falsely advised, just say he misinterpreted the law. But there's a different connotation when you use the word false, as that's accusatory, and that's part of our problem here. We've got people attacking each other rather than trying to work together, but that's not your fault, nor is it my fault.
If I could just make the record clear, Your Honor, the documents he speaks of actually will show that Mr. Boone did not misinterpret, that he actually defended the city and said that it took 4, and that he was not convinced that there were any violations, and he made that defense to the Attorney General on behalf of the city.
But anyway, go ahead, Mr. Hill.
Yeah, Your Honor,
I thought you'd be quiet and let you finish.
I would agree with what Mr. Green just said. Mr. Boone has always known that it took 4 council people. I mean, that's historic throughout the city of Florida. In fact, when we had a hearing on July the 22nd, Mr. Eady got on the stand and testified that it took 4 council people, other than the mayor to make a quorum. Okay, there's never been any misunderstanding on their part about what constitutes a quorum. But if you review the letters that were attached to the complaint that Mr. Boone authored, he stated that there were 3 people in the meeting, except for one occasion, which was on the 17th, when he said that based on news reports, there were 4 or 5 people in the meeting. And then he sent a letter to the Attorney General, telling the Attorney General that his own clients, his own constituent clients, were violating the Open Meetings Act. But he was only identifying 3 people and the mayor that had been in a meeting. When you look at those letters and see exactly what he stated, so this whole thing got started with the mayor meeting with 3 people, and that being an open record violation. We have 33 counts and an amended complaint. And I believe I counted last night that 26 or 27 of those counts have to do with Open Meetings Act violations. And here we are today, and the only violation that they can come up with after amending the complaint, 30 months later, well, in January they amended the complaint, almost 2 years after the original complaint was filed. And we got 1 potential Open Meetings Act violation regarding a committee meeting that was held less than 24 hours after they changed the Constitution and changed the Constitution of what is a committee from a 1-person committee to a 3-person committee. And the mayor says that she participated in a meeting on February 4th. The individual who reported that meeting states today that he didn't know exactly what the date was. It could have been at the end of January or sometimes after she was sworn in. So here we are today with basically, as far as the Open Meetings Act is concerned, with arguable proof that there was a committee meeting on February 4th that potentially violated the Open Meetings Act. Nothing else, the January 17th, February 6th, February 7th. And then you got potentially a finance committee meeting on the 20th to talk about paying Mr. Baster. Or I think it was, actually, they went to the bank together to transact some business with a car.
That was a meeting. The evidence was that there was a meeting.
Okay, it was, they all met at City Hall and walked up to the bank to change the car. So here we are with these, what I would call very insubstantial potential technical violations of the Open Meetings Act. And the mayor is responsible for this violation to the extent that she should be removed from office as being incompetent, malfeasant, and misfeasant in office. Terms by which there are no definitions in the City of Gordon Code. And in fact, I can't even find any definitions of those terms in Georgia law. So it's completely vague, and that is, as I stand here today, is what actually constitutes incompetence on the part of a elected official. Now, if Mayor Lou had been indicted for a crime, a felony crime, let's call it, then the governor would have to appoint a commission to determine whether or not whatever it is she's accused of relates to her ability to carry out her duties going forward. And if they determine, that commission recommends to the governor that that charge would affect her ability to go forward with her duties, then the governor can temporarily remove her from office, pending the resolution of those criminal charges. Now here, Mayor Lou is accused of not a crime, but misfeasance, malfeasance, and incompetence in office, based on having a committee meeting on February the 4th, less than 24 hours after the committee was expanded to include 3 people. And the charter of City of Gordon says that one person, a Superior Court judge, can overrule all the people who voted to put her in office and permanently remove her from office, not temporarily pending a jury of her peers determining whether or not beyond a reasonable doubt she has committed a crime, but permanently remove her from office on a preponderance of the evidence that she has a technical violation of Open Meetings Act and these other allegations that are out there which deal with whether or not she's mistreated the clerk, whether or not
And that's where I want to direct your attention. Let me, and I understand what you're, first of all, I didn't write the city charter, so
right. No,
the charter is what it is, and it says it gives that authority to the Superior Court judge, and it just happens to follow this one. But I'm less concerned about the two alleged violations of the Open Meeting Act back in 2014 than I am the problem that appears to me when there's several of these city employees that have said she told me she could fire me and replace me, that she told me she would fire me and replace me. She denies that, and then denies that she said it's my way or Ms. Toll's way or the highway or you're out the door. And then I hear an audio, see a videotape of her saying, I can do a clean sweep. And I hear Mr. Dinsley say that he heard her say that she could get rid of all the employees and the city council. She denies saying any of that, but then I hear it out of her voice on the tape. I'm more concerned about the environment that created in the city and the fact that it resulted in the city losing its insurance because of the various EEOC claims that arose out of that, which she denied, but then it's right there in out of her own mouth on a videotape.
Well,
That's what I'm more concerned about that than I am these quote technical violations. I agree with you. If all you're looking at is two technical violations of the Open Meetings Act back in 2014, I wouldn't even be having closing arguments. I would have said, yes, she did it, but I ain't removing her for that reason. Let's get out of here. But that's not where we are. We got more serious fish to fry here.
okay, well,
And I want to alert you to my feelings and thoughts, because when I was standing where you're standing, it always helped me to be able to focus on what the judge is thinking about.
well, thank you. I appreciate that, Judge, and that's a fair concern. Let me address it this way. If we were talking about us right now being in May or June of 2014, I would really say that, that's a real concern. But we're standing here in June of 2016, 2 years and a half later, when some of the same people that filed EEOC complaints against her, i.e. Heather Harper, have come into this court and said that, hey, that's all bygone old news as far as being the mayor is concerned. Well, I hadn't had any issues, there had been no hostile working environment as far as I'm concerned for the last 2.5 years since she was suspended from office, which was in the summer of 2014. That's 2 years ago. So, to me, that says that what we're talking about here is an individual problem between the mayor and two people, the clerk and the police chief, and both of whom who have profited as a result of this so-called bad relationship between the mayor, because they both have filed claims against the city, and they both have been paid money as a result of their filing claims against the city, which neither one has gone through to a lawsuit. Both have been basically compensated by a city council who is hostile, majority of whom is hostile to her and therefore is very eager to pay off claims against her and then come back and claim, well, look what the insurance companies did to us. Well, these people were out there talking to the insurance companies. These are the people that the insurance company is dealing with when they get these claims. The clerk, the city attorney. That's how they're getting fed this information. That causes the insurance company to, quote unquote, write a letter that says your city is dysfunctional. They've not had any conversations with the mayor. They've had conversations with the city attorney and the city clerk to come to these conclusions. So you got people like Melvin Lawrence, who originally filed one of those EEOC complaints, the 4 people, one of the 4 people who is still the supervisor of the city. He didn't go back and file a second complaint. You heard the mayor talk about her relationship with him with regards to handling the gas policy. So you got 2 people who basically are still in a position that they will come here and try to say that they got a bad relationship with the mayor and the mayor should be removed from office. One of whom, Chief Hall, who tried to get her indicted, who had his officer go against the district attorney and come here and try to get her indicted for a crime. And Ms. Brown, who I believe, I'm not sure what's happening with this whistleblower lawsuit, but she may be still suing the city on the whistleblower situation. I'm not handling that, I'm not involved in it. But here are people who got a vested financial interest in continuing a dysfunctional, antagonistic relationship with the mayor. 2 people. And that's what we got going on here. So if you put the Open Records Act technical violations aside from 2 years ago, and we're going forward with what we still have involved in this complaint, and what I hear you voicing a concern about is this so-called undue harassment issue of city personnel. Well, the incidents that we're talking about that happened in 2014. That incident that we just saw the videotape happened 9 days after she was elected to office. On January 15th. She hadn't even been in office 2 weeks when that happened. And I'm not gonna say that was something that, makes me feel that she was showing ultimate leadership and having a conversation with an employee of the city and using that kind of terminology. I couldn't justify that myself. I don't say that that's something that she should be proud of. But at the same time, I know that when she came into office, she was dealing with an extremely hostile situation. Extremely hostile situation. Very racially charged, extremely hostile. And that's the way she chose to deal with it, which might have worked for her at the time, but it's certainly not working now because everything has changed. I mean, everything has calmed down. Nobody's at each other's throat. I don't think anybody is trying to have her indicted right now as they did. That was, I did represent her when a woman, what's her name, Robinson? Kelly Robinson tried to have her locked up because she said she made a terroristic threat. We went over to Twiggs County Magistrate Court. The magistrate court looked at a video of it and said, hey, y'all wasting my time. We came down here when Andy Hester said that the mayor had made a false statement, that he had a body cam on, and he brought all his evidence in here, right down the hall here in the grand jury room, and they said, you're wasting our time. Mr. Bright told him, I don't want to have anything to do. He's the district attorney. Nobody's ever accused Fred Bright of backing up off of a criminal prosecution. Never. I mean, so if I might take a point of personal privilege, he called me up and said, hey, this is the craziest thing I ever seen in my life. know I'm not driving this train. And I told, Chief Hall that, you know, he needed to get this out of my office. You know, I mean, this is what this woman was dealing with. That's all I'm saying. A very hostile group of people who took it very seriously that they wanted to remove her from office. And of course, I say, and I still say, that it was all racially motivated. Now, I know the judge, I know you put a lot of stock in what Mr. Denson said. Well, I put almost no stock in what Mr. Denson said. And the reason I put no stock in what Mr. Denson said is that I understand the cultural dynamics of a person like him in his position. And you know, we didn't get into all of the details, and you know, I got cut off with regards to his history. But the history is, I don't think anybody was disputed that the man was shot in the Okay.
Just how we can get beyond the evidence.
Well, I'm gonna think
You know, hard for me to imagine that this is all just a matter of race. Again, going back to the fact that whether she's black or whether she was white, it wouldn't have mattered. If anybody comes in and tells the employees, I can fire you all, including the city council. What's that got to do with race? Or when the mayor says, you know, I can get rid of you if you do it my way or it's a highway, what's that got to do with race? That's got to do with leadership and being the mayor. So, you know, it's easy to say, oh, it's just all racial, but
I just said it was all. I said
you said that in your opening statement,
I
and
said
you
it
said
was-
it again now.
I said it was motivated by race. And I still stand on that.
If somebody came into my office and said, I can get rid of you, I can fire you today, it wouldn't matter to me whether they were black or white. That got nothing to do with race.
I agree. I agree with you. I agree with
Why
you.
is it motivated by race?
Well, let me tell you why.
It's too easy, you see, that's just too easy.
I understand, and I don't like to play the race card, just to be playing the race card. Okay, that's not something that you know, and I do a lot of racial type cases. But I don't like to do that. And I only do it in this case because I have talked to the folks, Mr. Boone, who I think is the leader of this whole charge, along with a few other people. And I have seen how this all came about from a temporal standpoint, from a timing standpoint. This woman comes in the office, and within less than a month, a few weeks in office, 2 or 3 weeks in office, she's got 4 EEOC complaints. Okay? Of course, I filed a few EEOC complaints in my day. One of the tactical reasons to file an EEOC complaint is just simply so somebody can keep their job. And Ms. Brown testified to that. I said, how did this come about? She said, oh, we know I needed to keep my job. So you file an EEOC complaint because if somebody fires you after you file an EEOC complaint, you may have had a terrible EEOC complaint, but you may have a damn good retaliation complaint because they got rid of it. So you can file an EEOC complaint just to keep your job, and she testified to that. She said that that's what she did. She filed it to keep her job. And you also heard testimony concerning the fact that, and it may have been hearsay, and I think it was, but the mayor testified that Ms. Harvard told her that former Mayor Turner said, well, you're gonna fire all the blacks. She's gonna come in the office and fire all the black people. all the white people and hire black people. And then there was statements out there on the internet talking about she's gonna hire all her relatives. So when she came into office, this was the environment. This is why I said it was motivated by race. Because the rumor mill was in this community where you got the entire office staff at City Hall is white, and you got a rumor mill out there, or I don't know if the mayor said what he said, but that's what the talk was that he said that she's gonna come in there and fire all the white people. So that's why I say it's racial. Now, are there some other issues involved concerning leadership, good judgment? Obviously, yes. Definitely. So the two combined, you had a situation where there's a racial atmosphere going on, and then at the same time, you had some things that the mayor did that, in hindsight, just was not smart. I can't sugarcoat it. I mean, you call people in and tell them that, you know, I can get rid of all of you guys. That's just not a good way to handle business when you're the new guy on the block, regardless of your race. So that was some mistakes there, and she admitted to that. She admitted that she made some mistakes, and she's also admitted that she's learned and grown from the process, and I think the evidence is that the relationships have improved between her and some of the employees, at least. Some of the staff, people there, that they have improved. But what we here to talk about, Judge, is whether or not, and you didn't write I grant you that you didn't write this chart that we're here on today, but it still comes down to the fact of whether or not what we've heard here is in all good, equitable jurisprudence enough to overrule the democratic process in this particular city to remove the duly elected mayor from office based on what we have heard and where we are in the process. 30 months down the road, after she was a new mayor, coming in with the environment that she came into, with a city attorney, like I said, you know, in my opinion, that's what should have happened first, is that she should have got good legal advice from somebody that she can trust. And it was obvious from the beginning that she did not trust Joe Boone. And that has led us to a complication and a multiplication of problems going forward. So I think in the totality of the circumstances, Judge, you gotta look at it from the standpoint of, given all I've heard, given what I've seen from this mayor over the course of the last 30 months, given what has transpired back and forth, people, and I agree, attacking each other, some of it being on her, some of it not being on her, whether or not, from an equitable standpoint, it is incumbent upon you to take her out of office. Given the motivations of the people you heard testify, now Mr. Edie, I mean, nobody testifies about this, but I think you know this, he's the mayor pro tem. So he's gonna be the person that goes into the mayor's spot if she's removed from office.
Well, they didn't have an election, they didn't have an election.
I don't think so. The last couple of times that she's been suspended from
That was
office.
temporary, but if she would be suspended permanently, they'd have to have an election on some schedule. I don't know when it would be in the spring, at certain times, I'm sure the law you can have, you do it better than I do.
Yeah,
Well, I
well,
think it'd probably be in March,
you may be
have a
right.
special election in March, I think would be.
You may be right there. I'm not being opined on that, but, yeah, that, whatever. You know, she's got roughly 18 more months left in office. Yeah, it's June now.
June, that'd be in November, yeah.
Yeah, probably be in November. Special election. But she's got 18 months left in her term. She's served for 30 months. I just don't think the equities of the totality of the situation here favor removing her from office based on what we heard in terms of the just don't feel that it would be prudent to put her out. That's what I think. And with that, I'm gonna sit down.
Thank you very much. Thank you for your comment. Mr. Chairman?
Thank you, Your Honor. I won't belabor the Open Meetings Act. I think the court has hit on the violations that exist. I think Mr. Kendall admits some of them. I don't agree they're just hyper-technical violations, but that being said, that's not what concerns us about this suit. That's what we said in our opening statement. That's what we said throughout the pendency of this case. In fact, when this case was filed in March of 2014, I think it was filed on March 11th, the reason that it was filed so quickly wasn't because my clients were desperate to remove the mayor from office. It wasn't racially motivated. There was no malintent. It was because as our firm processed this case and began to get involved, we became acutely aware of the dangers to Chief Hall's employment and Tawana Brown's employment. And we rushed to file a lawsuit as a result. And as Your Honor will recall, it was still some time after that that we even saw the TRO. It wasn't immediately. And we said in that first hearing we did so with great reluctance. But reluctant or not, we felt that we had to do it because this case is about the destabilization of the city of Gordon. It's about the dysfunction as the GMA identifies it in their letter. It's about a mayor who came to power for what, not power, but she came into office and for whatever reason began threatening people's livelihoods, threatening their jobs. Within the first 60 days, she's faced with 4 EEOC complaints. And Mr. Kendall says things have settled down, but what I notice is there are 4 EEOC complaints in her first year in office. There are 2 repeat EEOC complaints in her second year in office, and we're only halfway through 2016. And the reason that concerns me is because of what Terry Eady testified to at the end of his testimony. He said, things are more stable in Gordon and things have calmed down. He said the temporary restraining order went a long way to help. He said that George Wynn's election as a city councilman went a long way to help. Now we've got another vacancy. Tommy Smallwood resigned 2 or 3 weeks ago on the eve of this trial, and who knows who's going to come to power. I don't, or be elected. I don't know. Mr. Kendall doesn't know. I don't even know who the candidates are. And I don't think at this time they even have any declared. So we don't know what's going to happen, and we don't know how the mayor is going to act. I think she's acted erratically throughout her tenure. You know, 6 EEOC complaints in a 2-year period is nothing to make light of. And I will say this, I haven't done as much EEOC litigation as Mr. Kendall. I've only handled 2 or 3 suits. But I've never looked at a claimant in an EEOC claim and said they profited because they felt discriminated against and felt like their jobs were in jeopardy and they happened to get paid compensation. I've never said they profited from that. Ms. Brown did file a whistleblower suit. And there's a settlement with the journalist. There's a lot of stuff going on. There's a lot of litigation. There's just a large amount of litigation in her first 2.5 years in office. And then you turn around and you look at the debts that the city could be accruing. I don't know what the legal status is, but Mr. Jones, Ronnie Jones, has some amount of money outstanding that he was never paid, $10,000, $15,000. Bill Baskett has $21,000 at least in outstanding fees because those are the 2 invoices we've seen. And I will acknowledge, I don't think Mr. Baskett's due anything. He should know that the city requires a written contract. And if you proceed without one, I think, you know, it's, I think you've done so at your own peril, but he could still sue the city. That's $21,000. Plus the $10,000 retainer that's gone, the city has not gotten back. And then on top of all that, on March 4th, 2014, the city lost its liability insurance policy with GMA, which it still can't replace. They're uninsurable. The dysfunction was so bad that the insurance company cut the policy. And Mr. Kendall says it's because the clerk called or Mr. Boone called or somebody called. There's no evidence of how they found out. I would imagine they found out because attached to their cancellation notice are those sheets showing the claims from the prior 5 years, and it lists the 4 EEOC claims. And it lists 2 complaints by the Attorney General that they were defending based on the Open Meetings Act. So I imagine they didn't find out from the clerk or the city attorney or anybody else because they were gossipy. I imagine they found out because the city was processing its claims. And an insurance company, I think GMA, just like my car insurance, if I had 6 accidents, 7 accidents in a 2-month period, USA is probably gonna cancel my insurance. And I hope if somebody else is on USA and they have that many accidents, they cancel their insurance so I can save more money. That's good business sense. But they lost the insurance. And you have to weigh the evidence and you have to weigh the equities. And I listened to Mayor Lou, and I feel sorry for her in a lot of ways. She says, I'm just trying to do my best. And she's not being successful. Mr. Kendall says it's not a good way to handle business, it's just not smart. That's incompetence under the chart. And I don't say that to insult her personally. It's not a personal comment at all. I'd be horrified for somebody to think it is. But the fact of the matter is the code provides 3 reasons for removal. Incompetence is one of them. Incompetence is lack of ability. That's how Webster's defines it. And you look at her other actions, Mr. Kendall says things have calmed down, yet you've got this DUI checkpoint where she's interfering with one of her own officers' investigations, potentially jeopardizing his life because she's the mayor and she doesn't want to be inconvenienced. Same thing we saw when she wrote to the sheriff in the other county. And
This guy.
yeah, I'm sorry, this county, but not the police chief, but you're correct. It's the Wilkes County Sheriff. And she says when she's testifying in one breath, I've learned and I've grown from this process and I've learned more about government and how to be a mayor. And in the next breath, she says she never challenged Mike Hall's job. But we've seen the video. Councilwoman Toll said the same thing. Councilwoman Toll says, I was never even at the meeting. There she is, in the corner. And she says, I've never seen Mayor Lou challenge anybody's jobs. Well, there it is on the video, and there's Councilwoman Whipple, and there's Councilwoman Tolles. And I acknowledge that their 3 stories today match up perfect. They just don't match the videotape. They just don't match the documentary evidence. They don't match the minutes to the city council meetings. They don't match the truth. And that's the problem. So yes, there's tension, and it continues. I'm glad Ms. Oliver's doing better. Can't pronounce her name very well, but I'm glad she's doing better. But Tawana Brown's not doing better. Mike Hall's not doing better. And those are 2 of your department heads, not just line employees. Those are your department heads. Those are people you work with every day. And it's a problem. So we think we've established what we set out to prove. Yes, we've got some technical Open Meetings Act violations. But we've also shown that the city was destabilized. The mayor not only took the keys to the personnel files, but Your Honor pointed out it yourself on Plaintiff's Exhibit 40, ordered Tawana to turn over the keys. That's how she approaches things. That's how the mayor approaches things. It's a fist. It's a fist approach. It's a run over everybody approach. And you've got this contractual agreement with Bill Baskett. And I've heard multiple explanations about this contract over the past 30 months. You approve Bill Baskett as a person to do the audit, but then you don't have any way to fund him. So you go ahead and sign a contract with him, obligating the city potentially to be on the hook for him. And then to try to remedy the problem, because the Attorney General tells you you need to fix the problem, you keep listing it on agenda after agenda after agenda, and when you realize you still don't have the votes, you keep tabling it. That's what the mayor told us yesterday she did. So it never comes back up. It's never disapproved again. It's just never voted on again. No efforts are made to stop it. And I forgot to ask her, and I don't know. I'm not really sure when Mr. Baskett stopped his work. It was sometime after he testified in the injunction hearing here. I presume he stopped his work. He apparently stopped sending invoices, but it's a huge issue. And I think even though, and I know we've lost count 34 on the directed verdict. I respect the court's ruling. I don't want to belabor the count, but I do want to note, it's the same conduct. The council doesn't approve an expenditure, and the mayor proceeds anyway. So whether that shifting of funds was legal or illegal, the council set a budget, she changes it willy-nilly. The council council says we're not gonna spend this $150,000, and those were her council people who voted that way.
That's been,
Or, excuse me, transfer. You're right, the court pointed that out, the transfer from the Georgia Fund to one, and it was Councilwoman Tolles and Councilwoman Whipple who voted not to do that, and yet the mayor still does it. And we certainly think we've shown the harassment of the personnel. I think it's an odd law in the charter. I think it's odd that the charter provides perhaps for removal of an officer, or excuse me, the mayor for misfeasance, malfeasance, and incompetence. I understand Mr. Kendall's reservations, but that's the law of the city of Gordon. And there's a case, Northway versus Allen, 291 Georgia 227, where the Supreme Court dealt with similarly strange removal of mayor provisions. And while they overturned the removal of the mayor, they did it because the mayor really wasn't given any due process rights in that case. He wasn't told what he did wrong or why he was being removed. It was just bare allegations by city council, which this is not. But I pointed out because when Justice Benham drafted his opinion, he did not belabor the point that elected officials can be removed. All he said is that elected officials have a property right in their office that cannot be taken away without due process of law. And that's what we've been here for 2 days dealing with, is due process. We think the equities weigh in favor of removal, and we think that the future of Gordon, to some extent, certainly Mike Hall and Tawana Brown depend on it, and we would ask the court to take that ultimate remedy and remove Mayor Lee from office.
let me just ask you quickly, that's the, ultimate, judge to override the democratic process of the will be, the vote of the people of the city of Gordon. That's pretty, that's the, I forget what, atomic bomb, you have another word for it last time we met, but it's pretty.
Nuclear option.
Nuclear option, that's where that's the nuclear option, that's a pretty significant thing to do. If you've done any research, you got any, I realize you got that one decision that indicates, obviously it can be done.
Right.
And I think that is the law in this instance, but, how do you see this, again, and there's no question, giving credit to the testimony of Ms. Brown and Mr. Hall, they're in their position as a fiddler on the roof, they could fall off any moment.
That's right.
And I understand the way they feel and the, concern they would have, but is that sufficient to override the will of the people of the city of Gordon?
I don't think
For 18 months, because they could express that will again, but then, I don't know if when they held their election, but it'll be within a year.
Right.
Year and a half at the very least.
November 17th.
Yeah, it'd be a little over a year, they'll be exercising that right again.
Right.
14, 15, 16 months. So you got any case law or any thoughts on that part of the argument that Mr. Kendall addressed?
I've got some thoughts, and let me say this. Of course, it's not just their concern for their jobs that motivates us. We're concerned about the misfeasance, malfeasance, and incompetence issue. I haven't found a case on point with this particular provision of the charter. I've looked. I know Mr. Kendall's looked. I'm sure if he had found one, he would have briefed it. I know that when the city was contemplating rewriting their code last year, and that was pending in the legislature, as I understood it from the Regional Development Commission, this is a somewhat common provision in southern Georgia and middle Georgia city charters. So the fact that it has never come up is a little odd. In the case law I've done throughout the case, both at the beginning of the case and to now, case after case, when it deals with these sorts of issues, only deal with the fact that an elected official has a liberty interest in their job and a due process right. And I've never seen any guidance beyond that. So I don't have any case law to draw the line. That's what I was telling my co-counsel at lunch, is it'd be nice if it was more like an automobile case and there was a line in the sand and I could tell when we crossed it. And
Sure.
There's not. And that's why I made the point in my opening that I don't think it's one instance, but I think multiple instances give rise. And I do think that while this case has been drawn out for probably 28 months or 30 months, I think while it's been drawn out, that has changed the course of some of the conduct of the defendant. And that's why I think you see a change in some of what she's doing. I mean, it'd be an easier case if I could point to something she did last week and say she just transferred all this money. I understand we're talking about allegations from 2014 and a few from 2015, but that's just the nature of where we're kind of frozen in time. So,
Thank you very much.
thank you, Heather.
All right, thank you everybody very much. We are adjourned.
Thank you.